This week brought some really disturbing headlines from several cities across the United States. Federal immigration agents arrested a number of immigrants during, or right after, what were supposed to be routine green card interviews. These incidents, honestly, have shocked families and sparked protests nationwide, with advocates saying that people's trust in the immigration system is starting to erode. In Long Beach, a 60-year-old woman of Indian origin, who has lived in the United States for more than 3 decades, was actually detained during her interview, even though she had an approved immigration petition supported by her U.S. family. In San Diego and Salt Lake City, attorneys reported similar arrests, mostly based on allegations of visa overstays, even for people with completely clean records and deep ties to their communities. These events have led to confusion, protests, and, some pretty fierce debate about what really happens when enforcement meets what should be a climactic administrative appointment. In this video, we're going to walk through the context of these arrests, why they're happening during green card interviews, what the law actually allows, how USCIS and immigration enforcement are working together, and what applicants should know so they're prepared instead of being caught off guard. If you're liking this video, please hit the bell button, subscribe, and like it so you can get updates straight to your smartphone. Now, let's get into the video. When most people think of a green card interview, they imagine a quiet moment at a USCIS office where an officer verifies information about a marriage, a family relationship, or employment. It's usually the final step in a long and detailed application process. But in late 2025, immigration enforcement and adjudication are intersecting in ways that, honestly, might come as a real shock to a lot of applicants. While millions of adjustment of status interviews happen each year without any major issues, recent arrests at USCIS field offices are showing just how complex and, honestly, high-risk today's immigration landscape can be for some applicants. In San Diego earlier this month, there were multiple cases where immigration and customs enforcement agents waited inside USCIS offices and detained people right at their green card appointments. One German national and another British woman were reportedly taken into custody just after finishing their interviews, even though they had family ties and no serious criminal history. According to lawyers who represent these families, the common thread was alleged overstays on previous visas, a factor that immigration attorneys usually considered manageable during the adjustment process, especially in marriage-based cases. In Salt Lake City, a similar scenario unfolded when a husband of a United States citizen was detained by ICE agents during what was supposed to be his final interview. His lawyers described him as having no criminal record and expected to receive his green card, only to see him taken into custody. In both the San Diego and Salt Lake cases, legal representation has suggested that enforcement actions were rooted in overstayed visas rather than violent or serious criminal conduct. Perhaps the most recent example comes from Long Beach, where Babeljet Bubbly Kaur, a 60-year-old Indian origin woman who has lived in California since 1994, was reportedly detained by ICE while attending her green card interview. Her family said the petition had already been approved and that she has strong ties to the United States, including children who are United States citizens. The family's confusion and distress reflect how unpredictable these encounters can feel, especially when people believe they're following every rule correctly. These arrests are not isolated incidents. They reflect a documented surge in immigration enforcement actions during the Trump administration's second term, where ICE has expanded interior enforcement beyond traditional priorities. Local attorneys and immigrant advocates have reported a noticeable pattern of detentions during immigration appointments, interviews, and even routine check-ins, a trend that many say has instilled fear among immigrant communities seeking lawful status. So, to understand why these arrests occur, it's essential to look at the legal framework and enforcement practices. USCIS is actually a part of the Department of Homeland Security, but its primary role is adjudication, processing visas, green cards, and, other benefits. ICE, on the other hand, is the enforcement arm that can detain and deport individuals who are in the United States unlawfully, or who have unresolved immigration violations, including past removal orders or certain violations of status. When a USCIS officer identifies a case where enforcement action may be appropriate, they can notify ICE, and ICE officers can take action even at or immediately after an immigration appointment. Overstayed visas are, honestly, a pretty common trigger. Under United States immigration law, a person whose authorized stay has expired can be arrested and placed into removal proceedings, even if they are in the process of adjusting status. In the past, many applicants with overstays were allowed to continue their green card interviews and adjustments without intervention, especially when the applicant had strong family ties or, other equities. However, enforcement policies can shift, And in 2025 and 2026, we are seeing cases where ICE is choosing to act on overstays at the point of contact. This represents a more aggressive enforcement posture that intersects directly with the adjudication process. It's also important to stress that, an arrest during a green card interview does not automatically mean denial of the immigration benefit. In several reports, attorneys expect their clients to be released on bond and return to the interview process after enforcement proceedings take their course. The legal path can be complicated, with immigration court hearings, bond hearings, and continuances, but the interview itself does not erase the applicant's right to due process. The aim of enforcement is removal or compliance, not necessarily denial of the adjustment application, but the consequences are still serious and disruptive. In contrast to overstays, other applicants with clean records may face arrest for reasons unrelated to the interview itself, such as old removal orders or data flagged during cross-agency database checks. USCIS, CBP, and ICE increasingly share travel, criminal, and administrative data, which means a case that seems straightforward on paper may suddenly trigger an enforcement referral if old information surfaces. These realities have prompted public outcry and protests in several locations. In Salt Lake City, immigration advocates and families have voiced concern about detentions happening in what is normally thought of as a safe environment. In Utah and elsewhere, protests have called for immigration authorities to stop arrests at USCIS offices, arguing that the adjudication process should remain separate from enforcement actions. For immigrants and families preparing for interviews, the situation highlights the need for caution and legal insight. It is no longer sufficient to assume that a scheduled appointment guarantees peaceful progress toward permanent residency. Applicants should ensure they fully understand their immigration history, any past violations, and how enforcement priorities may affect them. Consulting an experienced immigration attorney before attending an interview can provide clarity on risk, necessary documentation, and how best to present the case to minimize enforcement triggers. It's also essential to know your rights. Before any enforcement action, individuals have legal protections, including the right to legal counsel, the right to be informed of the basis for their detention, and the right to contest enforcement actions in immigration court. These rights do not prevent enforcement, but they do provide structured legal avenues for appeal and defense. Many community organizations and immigrant rights advocates have published guidance on what to bring to interviews, how to organize records, and what to do if ICE appears at an appointment. Preparing detailed documentation, maintaining up-to-date status records, and being transparent with legal counsel can help prevent surprises, although enforcement practices are still evolving. Another important point is that enforcement does not mean the end of the immigration process for everyone involved. In some cases, bond may be set, hearings may be scheduled, and the applicant may be released to continue proceedings. In other situations, legal defenses such as cancellation of removal or waiver applications might be available depending on the circumstances. Experienced counsel can really help families navigate these options. These arrest cases have also, drawn a lot of attention at the policy level. Immigration policy analysts, legal scholars, and advocacy groups are now discussing whether enforcement should actually be decoupled from the adjudication environment, especially for applicants who are following lawful procedures. Whether any changes happen will depend on political dynamics, legal challenges, and, honestly, public pressure, but for now, the enforcement landscape at USCIS appointments just remains pretty complex. For families and applicants, the most important mindset is not panic, but preparedness. Understanding your immigration history, seeking legal advice early, and attending interviews with transparency and complete documentation can make a significant difference in outcomes, even when enforcement stakes are high. As we continue to watch these developments unfold into late 2025 and heading into 2026, our commitment is to bring you accurate reporting. We'll explain not just what happened, but why it happened and what it means for your immigration journey. No one should have to walk into an interview feeling uncertain about their safety, and honestly, the more informed